Welcome to the LinkedIn Spotlight series, where criminal defense attorney Joel Chorny sits down with colleagues to share the stories and wisdom that define our profession. Today's guest is Barry Wax, Miami criminal defense attorney, 40-year veteran of state and federal court, and founder of his own firm. Let's get into it.
Well, thank you so much for agreeing to have a conversation with me.
A pleasure.
I have basically four big questions that I ask everyone who agrees to sit down with me like this. They're questions designed to give me information about your career, your philosophy of practice, gives you a chance to do some reflection on your experiences, to then give me what I need to craft a post to LinkedIn showcasing you.
Right.
And the idea is it's supposed to be flattering. This is not conversational journalism or anything. My goal is to create a post that you will be very happy to see posted about you, that I would want posted about me, basically. And the most common question that I get from people is, well, what's in it for you then? And selfishly, I find this is way more effective for me to network and get to know colleagues in other practice jurisdictions than trying to go to networking events or CLEs or things like that. Selfishly, I'm creating a referral network for myself that I will then, if the opportunity presents itself where someone needs a good criminal defense attorney in Miami, Florida, or Southern Florida, I would immediately think, oh, Barry's out there. Let me send the business to Barry. And similarly, hopefully, if you had the opportunity to send business to a criminal defense attorney in Tucson, Arizona, you go, oh, Joel's out in Tucson. Let me send them that way, and that kind of thing. So it's the cynical side of this is, yeah, I'm creating a referral network, but I've had people ask me how much do I have to pay for it, and the answer is nothing. I'm not making money off of it, not directly anyway. And there's no expectation of anything other than we have a nice chat. I get some notes off of it. We write a post, then we post it. You get some exposure. And hopefully it's the beginning of a long friendship.
I like that. A few things. First off, modern marketing, networking, what you're doing is perfect. It's in the nature of a podcast. It's just a link on LinkedIn. But at the end of the day, it's how you do market yourself and it's how you do expand your network. And that's really what matters. I spend quite a bit of time networking.
Yeah.
When I started practicing law, it was, if you're a good lawyer, business finds its way to your door. It's not like that anymore. There were 5 law schools in Florida when I graduated from law school. There are 13 now. That's a conversation for another time. But when my listserv, I'm on a federal listserv and I'm on a state court listserv. And most of the time it's, hey, I need a lawyer in Tucson, Arizona. Who can you refer? That comes up every day, multiple times a day. I'm in a BNI chapter. I'm in a Florida Lawyers Network chapter. And our WhatsApp conversations are, I need a lawyer here, I need a lawyer there. It's commonplace. And I hope you have the same experience in your groups that you're in as well. It's changed monumentally. But I think the marketing side of it, at least for the better, if you're in it. And you're in it honestly and morally and responsibly. That's really what it's about.
Exactly right.
Yeah.
So I'll ask you these questions. I do tend to have follow-ups or things that I find interesting, but it's one question that's going to get to your origin story, a question that goes to a particular war story of yours that has had an impact. The next question is lessons that you've acquired from owning a firm. And then my last question is asking for practical advice for the next generation. And so I'll ask you for questions, but those are the areas just to give you a sense of they're not hardball questions or anything.
They're all good.
All good. So
all good, man.
Let's do it.
Let's rock and roll.
So we'll start at the beginning. What first drew you to criminal defense? Was there a specific moment, influence, or experience that set you on this path?
You know, it's interesting. It's kind of like I always say, the old adage by Yogi Berra, when you come to a fork in the road, take it. I had never planned on being a lawyer, much less a criminal defense attorney. And when I was in my second year of law school, I entered the mock trial competition and won. And the professor who was really running the program said, Barry, you know, you've already read the book that we use in the third year clinical program. You're well advanced from what we teach. Why don't you go to the public defender's office as a certified legal intern? They'll let you try real cases. So I did. And I was so fortunate because I was assigned to the courtroom of a wonderful judge. He's since passed away, Sidney Shapiro. And I had four great supervising attorneys back then. This was 1984. And from the first day I walked into the courtroom, they saw that I was at home there and I had a talent for it. And they gave me a lot of responsibility, running daily calendar, meeting with clients in the jail, and most importantly, trying cases. I had 6 felony jury trials my third year of law school and won them all, knocking. And so the public defender's office hired me. They offered me a job. I accepted it. I never interviewed with law firms. As soon as I found my way into a criminal courtroom, that was where I belonged. And when I think back on my life experiences that way, it's kind of interesting that it led me to this path. And I think it was my destiny, for what it's worth. I grew up in an Italian restaurant, and I grew up around people who were connected. And I grew up around longshoremen and Teamsters. And then in college, I majored in film production and I made movies. And I worked in the movie business. I worked on sets and I made movies when I was in college. And I was working on major productions with Universal Studios or ABC Television. I turned down a job. I didn't want to drop out of college a second time. I had dropped out once already. But I was offered a job to go to work on a little film called Caddyshack.
I've heard.
I turned it down and went back and finished college. But that's my storytelling background, which serves me so well as a trial lawyer. And so when I had the opportunity to really set foot in a courtroom and tell stories to save people's lives or affect their future, I was like, well, here I am. This is what I was meant. This is what I was meant to do. And that's how I ended up being a criminal defense attorney. And after about 3 years in the public defender's office, I got hired by a criminal defense law firm, and I was exposed to federal court. And I got to travel around the country a bit. And then a year later, I hung out my own shingle and been doing it ever since.
So let me just make sure I got that right. After a year of working for someone else doing private criminal defense, you opened up your own practice?
Yes. That's correct.
Great.
It was a situation that became necessary because it's an interesting story. I tell it to this day, and I was so bothered by it back then, and now I think it's a badge of honor that a lot of attorneys carry with them. I had been handling 2 cases. One of them was a Bolita case, which in Miami was the lottery before the lottery was legal, and so it was a numbers game basically that was run in the Latin community. And there was a search warrant executed, and this individual was charged with running an illegal lottery, and the partner assigned the case to me. At the same time, the partner assigned a second case to me, which was a federal case, interference with a flight crew, which is a pretty serious felony and still is to this day, actually more so nowadays than ever. But this was 1987, 88. And so I had worked both cases up, and we went to court on the trial date on the Bolita case, the lottery case. And the judge was everybody knew the book on this judge, Phil Knight, that if you had no prior record and your guideline range was in a certain level, your offer was credit time served for the time you spent in jail when you got arrested, and a withhold of adjudication, which is no criminal conviction. And you couldn't play games with Judge Knight. He was like, take it. If you take it, you take it. If not, you want to go to trial, you go to trial. So you didn't even have to negotiate with the state. And I told the partner, I said, look, this is what the deal is. This is the plea offer. It's from the court, not the state. They want jail time. My advice is that he take it because we had lost a motion to suppress the evidence for a violation of his constitutional rights, a Fourth Amendment motion to suppress issue. And the judge had already ruled on it, so that was a dead issue. And other than that, the facts showed that he was running a lottery. So the partner said to me, no, go in and reject the plea. I want the state to dismiss the case. And I'm not going to do that. I know this judge. I've worked in these courts for 3 years. And what you're basically doing is you're telling me to go in there and reject that plea. And when the whole thing falls apart and the judge says, get a jury, you're going to hang me out to dry. And ethically, I'm not going to do it. So I left him. He walked into the courtroom. And of course, he had the client take the plea and the case was closed. So then we go over to federal court, and I had this case, which was the interference with the flight crew. And I had met with the prosecution. We actually met with the magistrate judge because it was filed by complaint. It hadn't been indicted yet. And I had the client evaluated, and I was able to get everybody to agree that he had temporary insanity, which is a very difficult thing because if you practice criminal defense law, there's no such thing as temporary insanity. It's a made-up thing. But he clearly was having a psychotic episode, and I persuaded the government to dismiss the charges. So we go over to federal court. I didn't even sit at counsel table. He sat at counsel table to partner with the client and announced to the judge, who already knew about everything, it was all taken care of in chambers, that the government had advised they were going to be dismissing the case. And sure enough, the government gets up, announces a dismissal of the complaint. Judge accepts it. Everybody leaves. Everybody's happy. I go back to the office. I turn to one of my colleagues and I said, "It's been nice working with you. I'm about to get fired." And sure enough, my phone rang and I got a message. "Could you come upstairs to the managing partner's office?" Absolutely. I walked upstairs to the managing partner's office and the partners were there and they said, "It's not working out. Things aren't working out." I said, "Well,
I feel like
I don't know if..."
I missed a beat, Barry. It sounds to me like you did a good job and they fired you.
Yeah, that's exactly what happened because I'm not good at taking orders. Let's put it that way. I was told to go in and do something that I thought was unethical and I refused to do it. And I told the partner I wasn't going to do what he wanted me to do. And this particular partner decided that was enough for him. It was, what do they call it in the military?
Insubordination.
Insubordination. That's the word that I'm looking for.
Yeah.
But it was actually a blessing in disguise and a funny story that follows that up. So I went and opened up my own practice and I had two clients who came with me. And both of them gave me retainers for $7,500 each. So I had $15,000 as I hit the ground first day out in private practice in 1988, which was a lot of money, $15,000.
Yeah.
And I said, wow, this is a great start. And of course, both checks bounced. It's an interesting, auspicious start, but it was really important that I did that because the truth is, I was very fortunate to be able to start my own practice at a really good time in Miami where you could practice strictly criminal defense law and make a living. And it took me out of the public defender's office. It showed me private practice for a year. And then it put me into my own practice. And I love it. I couldn't see it any other way.
Very cool. That's a great story, Barry. And good for you for sticking to your ethics and your morals. I'm glad that it paid off for you. It should always pay off, but it doesn't always. So I'm glad it did.
Well, yeah. And I think that a lot of attorneys, that's part of what I perceive nowadays, unfortunately, is it's a distinct lack of mentoring of young lawyers, which is that they don't know where the line is sometimes. And you have to know where that moral, ethical line is. I represent a lot of lawyers in front of the Florida bar who have bar grievances filed against them by clients or judges or other attorneys. And some of the stuff that I see come across my desk, it's like, what were you thinking? How could you do this? And if you had just had someone to talk to before you did it, you wouldn't be in front of the Florida bar facing discipline. So,
right.
Yeah.
I'm just going to move on to the next question.
Sure.
Take it as Drew. Every defense attorney has at least one case that really sticks with them. For you, is there a particular case, whether it's a win or a loss, or just a turning point that had a lasting impact on how you practice law today, other than the ones you've already mentioned, of course?
In 40 years, I've tried so many cases, I've lost count. I see lawyers put things up, tried 20 jury trials, tried 100 jury. I have no idea how many trials I've had in my career. I know it's over 100, maybe more, but
Sure.
I don't keep track of the names or the tally of wins and losses. That's for my fantasy football league. But the losses tend to stay with you more than the wins. And there's one case that in particular that I think about that was a federal trial. It was a possession with intent to distribute crack cocaine and a possession of a firearm during the commission of a felony. And this was before Booker, before the guidelines became advisory, as opposed to when they started, they were mandatory. And my client was about 20 or 21 years old. And so he's facing a 10-year minimum mandatory on the drug charge and then a 5-year minimum mandatory on the gun charge. And it was a pretty straightforward case where they were watching a crack house. They were watching people come up and do buys. And the police, they weren't doing buy busts. They were just watching to make sure they had enough to get a search warrant. They might have sent an informant in, probably did, to make a buy so that they could get the warrant. And then they go ahead and they execute the warrant. And my client's in the crack house and there's a gun in the crack house. And it's not a very strong case against my client. It's really not. And to make matters worse, the police officer had testified that he had a visual on the front door of the crack house. And where he was positioned from, he could clearly see that the client was selling drugs. He watched him actually do hand-to-hand transactions. So I call my investigator up and I say, let's go over to this place. I want to look at the scene. And we drive over to the location of the crack house. And oddly enough, there is a huge ficus tree in front of the house. It's a ficus tree is best likened, for those people that don't know it, to an oak. They have huge trunks. You couldn't even have a chain of people around them. It would take 6 to 8 people to go around some of these trees, but most of them, they're rather sizable. And it just so happens, from where the police officer said he was situated, the ficus tree is obscuring the front door. So I had my investigator take pictures and we set the whole thing up. And we're getting ready to have a hearing on a motion to suppress. And I go to see the client a few days before, and I prepare him to testify at the motion to suppress. And then I go to see him the morning before the hearing in the marshal's lockup, and I say, okay, remember what we did? And he goes, I can't testify. I said, what do you mean you can't testify? He said, I can't testify. I can't do it. I said, but all you have to do is say that you were in the crack house, so you had standing for the motion to suppress. He refuses to testify. We go into court. I can't establish standing. And the motion to suppress gets summarily denied. So we proceed to trial shortly thereafter. And we go to trial, and the police officer takes the stand and testifies. And he says, I was watching the door. I saw the client do hand-to-hand sales. He's clearly a crack dealer, whatever the testimony was. I cross-examine him with the photographs and demonstrate that he could not have seen what he said he saw and that it was not true. So we're doing great. We've got the case won. We get past the Rule 29 judgment of acquittal. The judge, of course, denies. And now it's time for the defense case, and I'm getting ready to rest. And the client turns to me and says, I have to testify. And I look at him and I go, what do you mean you have to testify? We're winning. What are you going to say? They're lying about me. They're lying on me. I got to get up and tell them I wasn't there. I said, wait a second. I said, you can't do that. Okay. First off, I haven't prepared you to testify. Second off, if you take the stand, you can't say you're not there, because if you say you aren't there, they're going to call a rebuttal witness because your DNA was all over a bunch of stuff in the crack house. And you were there, but it doesn't matter if you were there or not. This is a case about knowledge. This is a case about whether you were involved and knew they were selling drugs. And we're winning. Please don't testify. No, he says, I have to testify. And of course, you can't keep them off the stand. If a client wants to testify, they have to testify. So I put him on the witness stand, and I have to be very careful because I can't suborn perjury. And so before I put him on the witness stand, I say, listen, I'm going to ask you one question. It's a very important question. And the question is, were you in the crack house? Of course, I didn't call it a crack house, but were you in the house on this specific date? And your answer, as you've told me, is you weren't there on that date when the sales were being made. And we've already shown that the police officer couldn't have seen you there on that date. So please, when I ask you that question, say no. I would say, yeah, I'm sorry. I messed up the story. That he was in the house that day. I needed him to say he was in the house on a specific day. And I say, just say yes. Because it's true. You were in the house that day. You say it. Okay, do you understand? Yes. So he takes the stand and he testifies, and I get to the question. I go, and were you in the house on this date? And he goes, no. And I say, okay, maybe you didn't understand the date. Maybe I got it wrong. And I ask him again, and he goes, no, I wasn't there. And I move on. Jury goes out and deliberates, and the jury finds him guilty of the possession with intent to distribute and not guilty of the firearm count. So it was a 15-year minimum mandatory, no way around it. So we beat what would have happened if he pled guilty. And he ends up getting 10 years instead of 5 years. But that's not why I remember the story. The reason I remember the story is twofold. The first reason is the day after the trial, my office phone rings, and it's one of the jurors. And I pick up the phone, and he says, Mr. Wax, this is juror so-and-so. I want to talk to you. I said, look, I'm not allowed to talk to you because in federal court, you're not allowed to talk to the jurors without leave of court.
Oh,
Because but he called me. I had a little bit of latitude. I said, I just want you to know I'm not really supposed to be talking to you. And he said, no, I understand that. They told us that in the jury room, but I just need to tell you something. We were all ready to find your client not guilty before he testified. And I said, I kind of thought that was the case. Thanks for letting me know. And the second reason I remember it is because the client's brother called me after the trial. He was a scholarship football player at I think it was the University of Oklahoma. And he said, Mr. Wax, I just want to thank you for how hard you represented my brother, how hard you worked, and what a good job you did. That kid has never listened to anyone his entire life.
Nice. Yeah.
And I remember that story because I think it epitomizes the uphill battle that a lot of criminal defense lawyers face.
For sure.
Because a lot of our clients have lived their whole life making bad decisions. And I think it's important for us to be able to help our clients stop making bad decisions and start making good decisions. And that is one of the cases that really sticks with me because if he had just trusted me, we had nothing in common. I was much older than him. We were of different ethnic backgrounds, different races. And perhaps he just didn't trust me because he saw me as part of the system. I don't know.
Yeah.
But that's at least one memorable story. I had many.
I'm sure you do. 40 years.
That was good enough.
It was great. It was great, Barry. And Barry, just so you know, I have a hearing at 3. So I'm going to do a little bit more of directing you just to keep us on task so I can get the, and I hope you took no offense to it.
Oh, listen, I won't get so involved.
You're great. I wish I had set aside more time for you because you got great stories. I'm getting so much value out of them, just hearing them, knowing that even an experienced attorney such as yourself has had the experiences that that's
oh God,
it's confirming. So running your own practice isn't just about the law, Barry. It's about leadership, business, and resilience. Looking back on your time leading your own law firm, what's the most important lesson you've learned as an owner that you didn't expect going in?
I think that clearly the most important thing that you have to know is that law, while a noble profession, particularly so nowadays, is a business. And you have to learn to run your firm like a business, or you're going to be overwhelmed with work. You're going to be stressed out. It's as I've heard it described, you don't want to be working in your business. You want to be working on your business. And so that involves many facets. You have, for example, marketing and sales, because you're a business. Marketing draws clients to your business and selling pays the bills. So if you're not marketing and you're not selling, you're just like any other business. You're not going to make it. You're going to have to close your doors, or you're going to be more stressed out. And that's something I wish that I had learned many years ago when I opened my own practice, when I was just really happy being a good lawyer and business found its way to the door. It isn't like that anymore. So you've got the marketing and sales aspect. You've got your employees, personnel, and you have to manage your personnel. And the best way to manage personnel, in my experience, has been to get the employees, whether they're associate attorneys, whether they're paralegals, whether they're receptionists, no matter what their job is, to take ownership and understand what we're trying to do, what our mission as an organization is, what attorney-client privilege is, what confidentiality is, how to manage clients' expectations, how to deal with irate clients, which thankfully I don't have many. in my entire career. Most of my clients are very satisfied because we communicate. And that's also what I tell my employees. Communicate. Tell the clients what's going on. And also give them a good work environment. Give your employees flexibility to be with their kids, to go to their kids' events, to take care of a sick parent, or to have to go to a doctor's appointment on their own, or to take a vacation. Let them do that. And just impress upon them, you got to get the work done. And then you've got your factory, which is the way that your systems run. You got to have good systems because you can't keep reinventing the wheel every case. And nowadays it's even more true because a complex case, with which I handle many, used to be 2 or 3 boxes of paper files. Now it's 1 to 2 terabytes of information on an external hard drive. And so there's a lot of things that have to be done fluidly. And that goes to your motion practice as well, and maintaining a schedule and maintaining a calendar. And those aspects of the business are important. And then finally, there's your financials. You've got to be on top of your financials. You've got to have a bookkeeper to handle your bookkeeping and keep you on track. You've got to have an accountant. And there's a lot of companies now that do external financial, they give you what's called an outside CFP financial officer, and they can help you understand your numbers and your revenue and where your marketing's going right and where something's going wrong. And if you have the money to hire a new associate or to take on more office space, those are important. Yeah. And I'm also a big proponent of coaching. I think lawyer coaching is crucial. There's a lot of outfits out there nowadays. Not all of them are good, but if you find one that's good, listen, even athletes at every level have to keep getting better. And even when you make it to the pros, you have to get better. And so coaching is crucial, as is continuing education.
Yeah, how many employees do you have working for you, Barry?
Right now, I only have one. Believe it or not, I have my longtime paralegal working for me. I am looking for an associate. Associates are very expensive these days.
Yeah.
And good associates are extremely expensive these days. So, and they have to have a work ethic. And so you try to find a blend of everything. But I also use contract lawyers that are 1099 employees that work on their own time. Oh, and I have a law clerk who's a law student who's developing very well, I might add.
Good. I'm about to jump into the market for hopefully a senior associate, someone who could just jump in and take a caseload. So
that's what I'm the same way. That's what I need. I need someone who can hit the ground running.
Yeah, exactly. And then for my last question, it is, if you could sit down with your younger self or a new lawyer just starting out in criminal defense, what one piece of practical advice would you give them to make their journey smoother? You've given so much great advice, Barry. Don't feel like I haven't been listening. I have, but maybe just with the way I'm posing it, I might narrow it.
I think the best piece of advice that I can give them is that you have to love what you do. If you don't love what you do, especially in law, you're going to be miserable. If you're doing family law and you don't like it, don't stay in family law. If you don't have the makeup to practice criminal defense law, don't stay in criminal defense law. You have to find, especially if you're practicing law, find what you love and do that. Because if you do that, you won't be working. I'm at this 40 years. I truly love practicing criminal defense because it gives me an opportunity to really affect people's lives in a positive way. And as I alluded to earlier, my elevator speech is to say, I help people make good decisions so they can regain control of their lives. And when I go to a social event and people don't know me and they say, what do you do for a living? That's what I say. Because if I say to them, I'm a criminal defense lawyer, they go invariably, how do you represent those guilty people? And now we're having a defensive conversation. But if I say I help people make good decisions so they can regain control of their lives, they say, how do you do that? And I say, well, I'm a criminal defense lawyer. And they go, I never thought about it that way. No, because you only think about what you see on TV or in the movies. So that's all part of it. And it really is helping people. And that's what I enjoy doing. And so that's the advice I would give.
I'm going
You love what you do.
Yeah.
Go ahead.
Yeah.
Go ahead.
Because that's what happens. I get asked, what do I do? And I tell them I'm a criminal defense attorney. I say with pride, I'm not embarrassed to say it. But and I know, you know damn well that what's coming next is an invitation for you to defend yourself and your choices. So I'm going to try it the other way and see what kind of conversations I get instead, because I'm guessing it'll be a much less confrontational conversation.
Yes, and it really makes all the difference in the world. And also it's great for networking. Just find that work-life balance on top of it, which is very hard, especially when you're a criminal defense attorney who's in court, because your calendars are out of your control. And sometimes you can get things to work out the way you want, but other times you can't. And I love mentoring young lawyers. So thanks for the opportunity to impart a little bit of wisdom and knowledge. Yeah.
Larry, thank you so much for sitting with me. I will prepare the post. If you could please send me a photo of you, a headshot or whatever photo you'd like.
Sure.
Featured with the post. Send it to me by email. I don't know if you have my email address.
I don't know if I do either, but why don't you
drop it in the chat right now? Yeah. And that way, when we post it, we'll post it with a flattering photo of you. And we'll get that out in due course. We're working through a few interviews that I've done. I don't remember where you stand in the order of things, but we should get it out in the next few weeks or so. And
it's fine. That's fine. I do this stuff all the time. I did a podcast about a week ago.
It's so much fun, isn't it?
Oh, it's great fun. And look, like I said, I was in the movie business. And I was behind the camera, but I'm an outgoing guy and I like connecting with people. I had written some stuff down. I didn't know how freeform this was. But we really did hit a lot of great points and some stuff that I had in mind. So thanks for the opportunity and the invitation, Joel.
My pleasure. If you ever find yourself out in Tucson, Arizona for any reason,
it's been a while.
If you have the pleasure, look me up. I'd love to take you out to lunch or at least a cup of coffee or something.
Can I tell you a funny story?
Please.
1987, when I was working for the law firm, they sent me out to Phoenix for a federal case. It was a couple of Colombians that were caught with a load of cocaine going through Phoenix. Miami, of course, they're from Miami.
Sure.
And I'm a young boy, I'm just out. I had maybe one or two prior cases in federal court. And so they sent me out there to handle a pretrial detention hearing. And I had never done a pretrial detention hearing. They were relatively new. They hadn't become as prominent. Now I've done hundreds of them. I can't remember. But I'd say, so there were three defendants and there was me representing one and two local lawyers. And I said to the partner, I said, listen, Alan, what's a pretrial detention hearing? And he gave me an idea. And then I go, what do I do? He goes, oh, you won't have to do anything, Barry. He said, you don't have to do anything. He said, the other guys are there. They're experienced. They're local. They do it. So we get to the courtroom and we sit down and the judge calls the case. And she looks at counsel and she goes, all right, who's going to go first? And they both turn and look and go, he is. And so I did the detach. Look, it was a foregone conclusion. Two Colombians with more kilos of cocaine than Arizona had ever seen weren't going anywhere. But I remember going to the jail in Maricopa County the night before. And I had been in the jails in Miami. I had never been in out west for anything. Everybody in the jail was an American Indian. I had never encountered that. I'm used to Latinos and blacks and whites and not American Indians. It was quite a culture shock.
Particularly in the federal system. We have a lot. Now, the Major Crimes Act, where they're prosecuting local level crimes in the federal courts. I've got this. It's really not that remarkable of a murder case in federal court, except that it happened on tribal land among tribal members. The case would be perfectly at home in state court, except for the jurisdictional aspects of it. But because the feds have it, I've been dumped with terabytes of disclosure and thousands of pages. And it's a contract case. It's a CJA case. So I just got a voucher rejected because they're saying that I took too long to read the disclosure. So you got,
oh my God. So, but we're not getting paid now anyway.
We're not getting paid.
Stuff. Yeah. Did you have to submit a case budget to the circuit?
Yeah.
Yeah. Those are a pain in the ass.
Do that. Total pain in the ass.
Yeah.
I don't think I'm going to be practicing in this on the CJA panel for much longer. Certainly not.
How long have you been practicing, Joel?
I've been practicing for 15 years, but I've been in private practice for 3. I was a public defender for the first 12 years of my career.
Greatest job I ever had, by the way.
Mine too, until it wasn't.
Yeah. Yeah, that goes without saying. If I can ever give you any guidance in federal court, don't hesitate. I live in federal court. I don't really enjoy state court like I used to. It's good. It's fun. Don't get me wrong. But a lot of my work is federal, and I try the cases.
A few weeks ago, I found out that I screwed up pretty badly because I misunderstood what safety valve meant. And I knew that safety valve removed the mandatory minimum, but I didn't realize that a Class A felony is still not eligible for probation. And so I told my client, well, if you take the plea, you're safety valve eligible, and then the judge doesn't have to give you the minimum, and then we're going to argue for probation. But then the probation officer in the draft pre-SR wrote, not eligible for probation, and my client freaked out.
No, don't listen to them. You didn't screw up at all. The judge can do whatever they want after Booker. That whole thing, that whole structure is meaningless. Right. Meaningless. If you get the guidelines down low enough and his cooperation benefits him and you're in that range and you can ask the judge for probation, ask. Probation, half the time, they don't even know what they're talking about.
What I was going to do, my plan was going to be to ask, my client did a little over a week in custody before he bonded out. So what I was going to do is ask for time served and supervised release.
Yeah, it would be actually, the proper sentence would be probation.
Right.
Because supervised release is imposed after the court imposes a prison sentence. So if no prison sentence is going to be imposed, it's probation. So just ask for probation.
It's not for probation.
Ask for probation. That's all. And the new guidelines that take effect November 1st, for what it's worth, supervised release, there's a whole passage. And in fact, I'm going to do a seminar with the Sentencing Commission tomorrow for an hour and a half on the new guidelines online, which there's the supervised release provisions now say supervised release is no longer punitive. Don't think of it as punishment. It's rehabilitative. Stop treating people like they're still in prison. It's very interesting how lenient it's become. And you can really use that to your advantage.
Let me just, now I've got an expert on this on subject matter asks.
I'm not an expert. I'm just a good lawyer.
You're more of an expert than I am. So let me ask you, because where is it? They're telling me under 18 U.S.C. 3561 that felonies are not eligible for probation. That doesn't change.
I don't care. I don't care.
Okay.
I practice in the Southern District of Florida, one of the harshest jurisdictions. The 11th Circuit Court of Appeals is about as conservative as you can get. At the end of the day, if your client's done everything that they've got to do, did your client cooperate or was it just safety?
No, you did. In fact, the government filed a memo where they acknowledged that someone was arrested thanks to my client's cooperation.
So he's got a 5. So you're good. You could ask for probation.
All right.
Ask for it. The worst the judge can do is say no.
Yeah.
And they might say, well, the statute doesn't permit it. You can say, yeah, but Booker does. Go back and read Booker versus United States.
Yeah.
Okay. And there's a whole line of cases there. Have you joined NACDL yet?
I've not joined NACDL, but
okay, join NACDL, especially if you're going to do federal work. Great online resources, great monthly magazine, The Champion, great organization. And if you need a sponsor, I'll sponsor you.
I really appreciate that, Barry. Barry, I hope
my pleasure, Joel.
Not the last conversation we have. I've enjoyed it so much.
Better not be. It better not be.
I really appreciate it, Barry. Same to you. Don't be a stranger.
All right, Joel. Be well now. All right. Bye-bye.